Hello, Hivraj. Can you able to see my screen?
Yes, sir, perfectly.
Yeah. So this is intellectual property rights and intellectual property rights. So I'm like very glad that IFERP in, hello.
Yes, sir, you are audible.
Yeah, can you hear me? Yeah, I think I have some. Just a minute. I'm getting a second call. Sorry.
Sure, sure.
Sorry for the interruption. This is a need of our intellectual property rights is need of our. Let me go into my slide. So what is intellectual property? Intellectual property is the creation of minds. So it can be inventions, it can be artistic works, it can be like innovative things. Whatever innovation you do in your field can be categorized under intellectual property. So, say for example, if you are coming from an engineering background, so the projects, the R&D stuff you do, and thesis and all the research things you do for something developing innovative things, will come under intellectual property. When it comes to an industry, so the improvements made to the existing problems or improvements made to the existing solutions so that you develop an innovative product services. So that so intellectual property is generally something, the creation of mind. So whatever you innovate can be protected under intellectual property. So this is a classification of intellectual property. So there are different categories of intellectual property. Say for example, industrial property, copyright related rights, and traditional knowledge. When it comes to industrial property, the four main categories are industrial designs, patents, trademarks, and geographical indications. So this is the main classification of IP. I try to cover uh, the important segments that will be useful for students, entrepreneurs, and decision makers. So I think everyone might have heard the word patent, right? Uh, a patent is an exclusive right granted for an invention. Okay, it can be a product, it can be a process, or any other innovative things. Okay, so say for example, an individual can file for a patent. Individual can be an student, can be an entrepreneur, or can be a scientist. Okay, so an individual can file a patent. A company can also file a patent. Okay, so as far as the validity of patent is concerned, so say for example, if your patent is granted today, that is 2023, so the validity will be till 2043. So 20 years. Until 20 years, you have every right to sell your patent, to license your patent, to cross license your patent, or or you grant right to someone else so that they'll go for like mass production. So it depends on the thing you're applying for a patent. Okay, so the validity of patent is 20 years. So this is this is one of the important thing when it comes to intellectual property. Patent, it is an exclusive right where it. So this is all is patent. This is all patent is about. As far as industrial design is concerned, any innovative objects, that is, any objects, it can be a car, it can be a laptop, it can be a chair, it can be a motorcycle, it can be a mobile phone. So, if the design, if the UI, if the interface of that particular product is like, say for example, you have done your R&D, you did some research on your designing, and you're coming up with an innovative design, you can protect your product under industrial designs. Initially I talked about patent, right? That is concept, that is product and process will come under patent. When it comes to design, this is a one way of IP protection. Industrial designs that whatever may be the product, as I mentioned earlier, whatever may be the product, whether industrial applying for a design patent helps you to protect your design so that when you take it to the industry, when you like mass produce that particular product, and when you sell to your consumers, uh, third parties infringers won't, if at all third parties and infringers misuse or misinterpret your design, you have the right to sue them since you are the legal owner of the design you created. So uh, the slides which I showed you, like you can see like every mobile phone, like the mobile phone coming from different brands have different UI, different designs, right? So see how what is the protection? What is the protection for them? Because everyone can mimic or everyone can reverse engineer and like come up with a different thing, right? So duplicate some products. So in those scenarios, MNCs go for design patents where the design will be protected. And if at all you're applying for a patent in India, you need to like file a patent in India. And because wherever you want to protect, whichever country you want to protect, you need to go for the separate filing in those respective countries. Okay, this is what industrial design is concerned. So trademark. So I think like everyone may have like see the logos which I'm like currently like showing, right? Microsoft, Sony, Canon, Coca-Cola, right? So a trademark is a recognizable sign, design, or expression which identifies product or services from the particular source. Okay, it is the address of your brand. Okay, so whether you sell a cloth, whether you sell a mobile phone, or whether you sell a car, so what is your face value? The logo, the trademark is a face value. So uh, people come, people see your brand, uh, people see the royalty, people see the uh, power of your brand. They just come and buy whatever maybe the product, like whether you're going for a hotel, whether you're going to buy a car, or you are like having some food. You prefer a good hotel restaurant, right? So trademark is one of the important thing when it comes to intellectual property. Protecting your trademark in your business path, that is whether you're doing a restaurant, or whether you're doing engineering services, or whether you are like running an education institutions, you need to ensure your brand name is protected, because only then you can establish your identity over your brand name. So over the period of time, that is, say for example, after a year or 5 years or 10 years, so what stands will be the brand name. So either you are an entrepreneur, either you are a like startup, or either you are like coming up with your own branding. You need to ensure your brand name is protected under trademark. Copyright. I think everyone may have seen this copyright, right? It is the copyright. So I just I just categorize like what are the things that can be copyrighted, right? So music, as you everyone knows, songs, lyrics can be like protected under copyright. Software, books, novels, photographs, paintings, drawings, and movies, even movie screenplay and the entire UI of mobile phones, everything can be protected under copyright. Copyright gives the exclusive right to the author where the content is protected, and the validity of copyright is like protected as per the lifetime of the author. So, it eh, different types of things. What are the different types of things that can be protected under copyright? I've just listed it out. So it can be music, it can be software, as I mentioned earlier. I'll move to the next slide. Trade secret, right? So any confidential information will come under trade secret. For example, the formula of Coca-Cola. So not everyone can manufacture Coca-Cola, right? So they have a secret recipe where it is protected under the trade secret, so that only concerned person who have the right over to uh, who have the right over to use and sell it across the globe can So as far as the trade secret is concerned, is the subject matter of the trade secret is usually defined in the broad terms and sales method, distribution method, consumer profile, advertising strategy, and list of suppliers and clients and manufacturing process. Because these are the things like which runs a brand, right? See, everyone cannot be like everyone cannot be the number one, right? Say for example, if a brand is established or if a brand is very reputed, not because they just do like those marketing stuff, everything, the list of customers, their like their futures, how they market their products, how they do innovation in terms of like marketing their products, what are the different marketing techniques they do in terms of attracting their customers, how they sell the product in the market, will come under trade secret. So they invest lot of time in coming up with a different ways how they can market the product. So those things will come under trade secret. So unique way of preparation, unique way of like marketing the product. So all these things will come under trade secret. As far as geographical indication are concerned, so everyone have heard of Darjeeling tea. So a geographical identification is a sign used on a product for a specific geographical origin. Say, for example, Madurai, Malli, and jasmine flowers. Okay, rice. Like there are certain products which can be like produced only in certain location. Okay, so for example, rice from Tanjavur and also from like cloth products from like Coimbatore. So these are the as far as geographical indication is concerned. So say for example, if the largest production of certain product is from a certain area, that particular area can be pushed for GI tag. So it gives if at all a product gets a GI tag, it adds it will add it has an economical value. It can be like sold throughout India and also throughout the world under that particular tag, which gives lot of added qualities with respect to selling. So this is what geographical indications is about. So as far as traditional knowledge is concerned, right? Like there are like some knowledge which was like transformed from our ancestors, right? So say for example, like unique way of like preparing our food, preparing our like medicines in our home, and like unique way of like painting, or it can be anything. It can be anything. Okay. So this is what traditional knowledge is about. So this is one of the form of IP where you cannot protect the traditional knowledge, but you can use different ways of like methodologies to pass the traditional knowledge to your future generation through certain intellectual property things where it can be used utilized, because as you know, like some of the medicines which were patented in like other countries like European countries specifically, we have our own Indian medicines uh, for that particular disease. Say for example, like turmeric. Everyone like heard of turmeric, right? So this turmeric was originated in India, but like there are a lot of countries who have applied for patent in turmeric. So the composition and preparation of different compositions of a particular substance can be protected under patent rights. So I don't want to go deep into that, but as far as intellectual property right is concerned, you can be a student doing some R&D, doing some innovation, doing some like working on some improvisation of some existing product. Say, for example, you are an entrepreneur, like coming up with a solutions where the market needs is, or you are a like growing startup where you like think out of box solution for a particular problem. Everyone can use different form of IPs to protect their invention. They can protect their concepts under patents. They can protect their unique trade names, domain names under trademark. If at all they go for any digital innovation is in developing a mobile application or developing a web application, they can protect there. innovative content under copyrights. So as far as the trade secret is concerned, as I mentioned earlier, it is a it is an asset of the company. You as the name clearly indicates, trade secret, the asset should be maintained as a secret. The secret formula should be maintained. Okay, only then you'll have the business value for your product. Hope I covered the basics of intellectual property. When it comes to the type of IP which I mentioned earlier, that is patent, trademarks, and copyrights. Uh, I have categorize what can be patented, what is the duration of the protection and maintenance of the right, right? So as far as patent is concerned, as I mentioned earlier, so the validity of patent is 20 years. The annual fee should be paid every 20 years. And another thing is one important aspect of patent is, say for example, you're doing you're doing your R&D and like you're working on some improvisation. Please ensure that you don't publish it in public domain. That is one of the fundamental criteria of like filing patent, because if at all your invention, your R&D stuff, whatever researches you do, it is available in public domain, it cannot be patented. So please, this is the fundamental rule of patenting. Please ensure that you won't publish your content unless and until you file for a patent. Okay. And another important thing when it comes to entrepreneurs, students, right? See, please discuss your projects, that is your R&D stuff, only with people you have you believe, or you personally feel won't disclose to someone else. If at all you are discussing your idea with a company or an individual or a domain expert, which you are not completely aware, please file a mutual NDA. As everyone know, NDA stands for non-disclosure agreement. Say for example, you are like taking it to the you are like trying to like bring partners, or you are trying to show your product to companies who can take it and mass produce it and manufacture it and come in and like take it to the sales. Please ensure you sign mutual NDA with all legal IP classes, so that your content is protected and your idea is not copied or stolen by a third party or an infringer. Okay. As far as trademark is concerned, uh, I gave a detailed brief about the trademark. That is, any name, symbol, phrase, words ringtones can protected under trademark, and the validity of trademark is 10 years, and it need to extend for every 10 years. Okay. As far as copyright is concerned, software, poetry, films, books, music, photography, everything will come under copyright. Whoever that is whoever mentioned as the author of the copyright, that is the lifetime of the creator, that the validity of the copyright is the lifetime of the creator, that is more than 50 years. So this is what copyright is about. As far as design is concerned, as I mentioned earlier, uh, more or less patents and design are same, but design the it applies to the appearance of a product. So whether you are doing some product or some improvisation like an existing product, you can go for design patent. So as far as patent is concerned, if at all you're doing an innovative solution or innovative technique, you can go for patent. As far as the protecting the design of the object is concerned, you need to go for design patents. Trade secret, as I mentioned earlier, it is a secret recipe of how you do your business, how you sell your business. So it should be maintained at any cost. Okay. So I talked about discussing your ideas with you should not discuss your ideas with everyone, right? Unless and until it's patented. So patent infringement is unauthorized manufacture of sale, use of a patent invention, either directly or indirectly. So every company will they'll have a legal team to ensure that their concept, their product is not misused or misinterpreted at any cost. They'll have a dedicated IP team to look into that, to cross check and see whether everything and every concepts and every ideas which have business value is protected. So patent infringement is every company will do a periodically assessment of on publication of patents. Every patent application will be published uh, every week. So they will do a periodical assessment of whether any concept infringes with the existing patent. If at all they feel like if any of the because say for example I have an idea, you too can get the same idea, right? If at all we both go for same idea, say for example we don't know each other, right? But we are like filing patents in the same concept. Here what happens is who filed first. Say for example I filed my patent on April 1 and you filed your patent on April 2. So the person who filed on April 1 will get an advantage because he he the date is the critical criteria for like validating a patent. So this is the type of infringement. As you know, like some companies will like deliberately use steal other concepts and misuse or misrepresent their and it occurs directly because without no, that is doing a pro doing that is it occurs when someone directly makes use or sell the patent invention. As far as indirect infringement is concerned, they will be on the same trade, but without knowing they will misuse the thing. So, for example, say when a device is claimed in a patent, a third party supplies a product that can be reasonably say whatever brings a competitive advantage. Like for example, if it has a business value, some small companies will what they'll do is they will reverse engineer a product and they will sell into the market. In that case, a company can sue that small company for an indirect infringement. So as everyone know about Apple and Samsung, so this they have filed many infringement suits against each other. Infringement suit is nothing but you are I have patented a specific technology and your patent is similar to me. So if a company feels the patent is similar to already existing patent, they will oppose the patent and they will also file infringement suit against the infringer. Most of the Apple patents have been infringed by Samsung. Likewise, Samsung patents have also been infringed by Apple. So they will mutually file patent infringement against each other. So I just listed some innovative I think everyone will know about a certain feature of our mobile camera like pinch and zoom. Pinch and zoom feature was originally originated around 2015, 2016. Before that, you cannot pinch and zoom. Pinch and zoom was concept was first introduced in Apple phone. Okay, but somehow what happened is Samsung have used that particular feature to market the product which was launched around 2016, 2017. So iPhone went for a patent sue. They sued Samsung and they filed their infringement in U.S. federal court. So as I mentioned earlier, you need to ensure that each and every aspects of your invention is protected under IP. Apple and Samsung case is a prime example, a good case study of how your product, your idea can be misused by your competitor because Apple and Samsung are more or less the competitors in their own field, right? So when you start, you won't feel much problem as an entrepreneur. But say for example, when your company start growing, or you reached a position where where everyone can recognize you or identify you for your uh, products or services, you need to ensure your IP is protected from the scratch. Only then you can go into the next level of business because It is intellectual property management is one of the important aspects of whether it comes when it comes to patent management, trademark management, confidential information management. All these things you need to ensure it is protected, and there are proper guidelines, standard operating procedures on how to manage data and how to manage sensitive and confidential information. That is one of the important thing of like protecting your innovation. Okay. So everyone will ask, like, why I need to protect my intellectual property? Say, for example, you done a thing, right? You're taking it to the public domain and you are saying that, see, industry has this problem. I have like the solution for this particular problem. So you need a proof, right? So for that you need to go for patent. Okay, patent is nothing but a legal recognition to your invention. That patent will have the name of the inventor, patent will have the nationality of the inventor, patent will have the technological aspects of why you filed the patent. That is technological aspect of the solution. Okay. Every patent, that is whoever files a patent, what is the need for filing a patent? He has worked on an existing problem. He has and is coming up with an innovation and is coming up with a different solution for an existing problem. So what happens is like once we develop some innovation, we can go for patent. So apart from like patent, like say for example, you are an inventor, you are coming with a different solution. You are not going to like file only one patent. So whatever solutions you are doing, whatever improvisation, innovation you are doing in your area, in your technology, in your business services, you can go for different as many as patents. And if at all you come up with a different number of brand names for different products, you can protect those brand names under trademarks. And if at all you are coming up with a different kind of software products, you're coming up with a different, you're coming up with an e-commerce portal, you're coming up with a mobile application for public use, or you are coming up with an uh, anything that can be anything for that can be like used by larger number of people, it can be protected under copyright. So the need of the need to protect your IP is it contribute to your personal development, social and economic development. Being a patenter, you can sell your invention to your license your invention to a third party, because the reason for filing patent is you need to like monetize your IP, right? Monetize is nothing but make money. So whether if you have the infrastructure, if you have an industry, you can do it in your own industry. But if you are an individual or entrepreneur, you can license your invention to manufacturers and suppliers so that you will get the royalty for your invention. As everyone know about royalty, it is like whatever products they sell using your concept, you will be like paid a certain amount of certain percentage in the profit, okay, by those companies. So as I mentioned earlier, the importance of intellectual property is it set your business apart from your competitors, because you need to be as far as if at all you as I told earlier, if your company is growing, so everyone will look your product, everyone will look your innovative solution. They will try to misuse or reverse engineer or misinterpret your unique products. So in that case, you need to protect it through IP. Okay, you can sell, license. It can be it can be an important source of revenue generation. You can offer something new to your customers, uh, and say if you are doing some innovative thing, it is easy for you to market your brand. Okay. Say for example, nowadays, like whether you sell a mobile phone or you sell a cloth or you sell mobile accessories, you need to do marketing, right? You need to do branding. So in those scenarios, if at all like if a third party or infringer should not misuse your product. You need to ensure that your IP right is protected in any form. Okay, and also another important aspect is it can be used as a security for loans. As an for entrepreneurs, there are like government associations like MSME and startup ecosystems also, or these are the organizations where you can go for funding if at all you are coming up with an uh, innovative product or service company, right? So after protecting your IP right, you need to, as I mentioned earlier, you need to take care of the infringement. Infringement is copying one's patented idea intentionally or without his knowledge. Okay, so that is the direct infringement. So if your IP is protected, you also need to validate whether if someone is misusing, the legal team will take care of it. Okay, the legal IP team will take care of it. Take care of like whether if someone misuse or misinterpret the company's IP. Okay, you can earn royalties by licensing it, and you can sell it. So this is what, as far as the importance of protecting intellectual property right is concerned. How intellectual property protection contributes to the society. So it is definitely going to generate money, number one, and GDP, right? And it is also going to like give employment for different kind of talent, and it also going to like generate taxes. And if at all your product is like if an international company or international organization likes your company, they can come and invest on your product. So the this is what the uplift of economy. So intellectual property uplifts the economy. So it promotes innovation. Say, for example, if a specific area, if a specific field is like there are n number of people working on the improvisation of a specific thing, it promotes innovation, right? It gives lot of idea to the consumer, right? A lot of options. It gives lot of option to consume. Okay, so that they will have different products for different solutions. So you can sell your invention, you can make money, you can add value to your product. This is what monetizing innovation is concerned. You can be an individual, you can be an entrepreneur, you can be working in an organization or uh, working for an existing solution, existing problem. Okay, so whatever you do, if at all you protect under IP, it can be sold, licensed, and you can also create a value for the content. So this is what the side of it benefit consumer, owner, and the society. So there are certain laws and acts where they are clearly mentioned and how to patent, how to protect, how to brand, how to protect your brand name, how to protect your copyrights. So these are Patent Act 1970 generally talks about the rules and regulations to be followed for filing a particular patent. As far as Copyright Act 1957 is concerned, like uh, it it gives the summary of what are the things that can be protected under copyright, what are the criteria for filing copyright. As far as Trademark Act is concerned, it is applicable to the how you can protect your brand name. Design Act, how you protect what are the rules, what are the forms, what are the procedure to protect the shape, appearance, aesthetics of a product. So that will come under Design Act. Okay, geographical indication, as I mentioned earlier, Darjeeling tea and Madurai Malli will come under geographical identification. There are many products. There are many products like that. So as I mentioned, it will add economical value of the product. It will also promote the economy of that particular area so that it adds value to the product. Semiconductor integrated circuit layer design, it is a separate thing. It is applicable to the design of ICs. Being an from engineering background, everyone know about IC, like integrated circuit. So whether you are manufacturing an electronic product, you're manufacturing a laptop, or you're manufacturing a mobile phone, you will use different types of ICs, right? So whether you are a top company or a mid-level company, you need to ensure that your designs are protected. Okay, that is the separate law for semiconductor designs. Okay, the protection of plant variety and farm varieties, like say for example, there are specific species and there are specific plants that can be protected under plant varieties. As far as biological diversity act is concerned, it is like a rare plant species, rare like animals, and like all those things will come under biological diversity act. So I think I have covered the important aspects of introduction. That is what I have covered is like introduction to intellectual property. I'm yet to like go into the subject of IP management. Uh, so if you have any questions, I'm ready to answer. Hello?
Sir, am I audible?
Yeah, you're audible.
Sir, someone has a question they have put
Yes.
into the chat box.
Okay,
Are you able to see that?
just a minute. So it's asking, how does intellectual property affects individual business in a pure traditional design? Does intellectual property have to the right of an artist? So yes, of course. Say for example, as I mentioned earlier, the reason for protecting our IP is uh, if at all you're developing anything like improvisation of your existing product, you're going to sell a product or you're going to market your product. That's the reason, right? So in those scenarios, say for example, there are already 10 players in your field, and you are one among the 10 players. So what gives the competitive advantage is the protection of IP. So you say, for example, everyone is like they are very interested in a product. They are like impressed by the way you present your product, and they are going and buying your product. In those scenario, like there is a possibility that your competitors may develop a similar product like you. In those scenarios, you need to differentiate you need to like come up with your protection. So only then you can like do your business, right? So it is applicable also to traditional design, because say for example, if you are running a family business, or if you are running something a creative thing that which was developed by your ancestors of your family, and you need to like pass it to the next generation, the first and primemost thing is you need to ensure that it is protected under design patent, or it protected under copyright. Okay. Uh, as far as the artist right is concerned, like see, you need to understand the uh, that is differences between patent and copyright. As I mentioned earlier, patent is for protecting your idea and concept. As far as copyright is concerned, it is the medium, or it is the legal way to protect your creative things in the sense designs, your drawings, your paintings, or the software you programmed, or the UI interface, that is UI interface of your screen. So everyone know about the UI interface of like e-commerce portal like Amazon e-commerce or WhatsApp UI. Take WhatsApp UI. For example, take WhatsApp UI. The entire UI of WhatsApp is patented. That is, if you click on WhatsApp, the icon is patented. The icon is copyrighted, and the entire UI of the WhatsApp is protected under copyright, and the technological concept behind the operation and process flow of the that particular platform WhatsApp is protected under patent. So the visualization of the product is protected under copyright. The technological aspect of the product is protected under patent rights. Hope you are clear now.
That was wonderful, sir. If participants have any other questions, they may ask in the chat
Okay.
box.
Okay. I also have a second presentation where I explain about the importance of intellectual property in general and also for different kind of consumers, that is students and entrepreneurs and companies. So once we are done with this session, I can go for the second.
I think you can proceed, sir.
Okay. So hello everyone. I'm going to share my knowledge with respect to how you can strategize your IP rights. You can be an individual or you can be an entrepreneur, or you can be a company. So intangible assets. So intangible assets are the long-term resources of an entity. The name by itself that there is no physical existence. Uh, those assets are derived from the legal rights. Okay. So patents and copyrights are the intangible assets. Okay. Design patents, as I mentioned earlier, it can be touch and feel. Okay. So lifetime intangible assets, trademarks will come under unlimited lifetime intangible assets because you can extend your validity every 10 years. As far as patent and copyright is concerned, the validity of patent is 20 years. Once the validity is expired, the particular concept comes to the public domain, and each individual, each citizen has the right to use that particular patent. Okay. Now everyone will ask the question, then what is the need of protecting your invention? Say, when it comes to an individual who is going to sell this invention, he may go for 2 to 3 patents, right? When it comes to an organization, when it comes to a multinational organization, when it comes to an corporate company or an international company, they will go for maximum number of patents so that their invention cannot be used, or any part of the concept cannot be misused. So what they will do is they will create a patent portfolio. They will file thousands of patents. They will file 2,000 patents. They will file, uh, like Google has more than 10 lakh patents, and Microsoft has more than 10 lakh patents in their own business services. Okay. The reason for filing as many as patents is as I mentioned earlier, it is it is an intangible asset. Okay. And it it creates the value for the brand. Okay. And in the longer run, it protects each and every aspect of your business so that your reputation is not. So I just want to show some examples of intangible assets. As I mentioned earlier, trademarks and newspaper masses, internet domain names. Domain names, as I mentioned earlier, domain names are the important aspect, right? That is the face value of your, say for example, you're developing something in digital media, whether you are developing whether you're doing some service and you're marketing in digital media, you need to ensure that your domain name is protected, right? Only then. Uh, it can consumer can recognize you, consumer can follow you, you can turn that consumer that leads, you can turn a probable lead into a your customer. So domain name is one of the important names. And as far as non-competition agreements is concerned, you may work with your partner, or you may work with a third-party company, or you may work with a consultant. In those scenarios, you need to ensure that your business idea is protected, your data is protected. Say, for example, you're working with a third-party consultant, you need to ensure that you are sharing the right data. If at all you are sharing the confidential data, you need to ensure that you sign proper non-competition agreements so that your content is not misused at any aspect. Okay. As far as customer related intangible assets is concerned, see, whether you are a marketing company, whether you are an advertising company, whether you are a sales company or your product development company. So you are working for your client, you are working for your customer, you're working for your consumer, right? So the list of customer plays a major role. Say, for example, for instance, take a telecommunication company. Okay. A telecommunication company, uh, like uh, everyone is connected now through a phone, right? Say for example, if at all they need to send a message, how they can send you a message to your mobile number, right? So the asset of the telecommunication company is customer list. Okay, that is the asset of the company. So they need to ensure that the asset is not shared or misused under any circumstances. Okay. Order backlog and also customer relationship, how they maintain a good relationship, how they manage a good relationship with their customers will come under intangible assets. So more or less, goodwill, assets, copyrights, and how you use your copyrights, how you in terms of branding yourself, will all those things will come under intangible assets. With respect to like a person was asking about artists, right? How they can. These are the artist-related intangible assets. Say, for example, a reputed singer or a reputed uh, stage dancer is performing something live. It can be protected under intangible assets. So as pictures, motion pictures, television program. Say, for example, you're watching a television show or you're watching a live match. As soon as it gets the particular content is going to end, you can see copyright symbol, right? The circled C, that so and so copyright belongs to so and so person. Under any circumstances, without the consent of the authority, you cannot use your content, right? So this is one of the important thing. If at all you are using a third party, that is content created by somebody else for your personal benefit or business purposes, you need to ensure that you get the legal right, or you get informed about this to the person who created it. Okay, that is one of the important aspects of uh, protecting your streamlining your business. So as far as contract based intangible asset is concerned, uh, things which I listed is applicable to all type of industries, individuals, entrepreneurs, and startup companies. Say for example, uh, if at all you are licensing your if at all you are licensing your product to a manufacturer, or if at all you are licensing your product to a third party who is ready to take it and market it and sell it to the consumers, You need to ensure you're like drafting proper licensing agreement to attorneys with the with license laws. And as far as service contract is concerned, you need to ensure that like who has the right, what is the time frame of using your asset, like how, if at all, your asset, like what is the profit value of your asset, and how the profit should be managed, and how the profit should be like come to your pocket. So you need to ensure these things to service agreement. Lease agreement is, as the name itself tell, like it is like applicable only for a certain period. And as far as franchise agreement is concerned, the prime example is like food companies like KFC and like McDonald's. Will all those brands will they will franchise their product to third parties, where third parties will like use the brand name, and they will as far as broadcast rights is concerned, like this is IPL time, right? Like everyone can like watch live cricket, right? So the those sports channel, they need to like bid, and they need to like uh, ensure that they buy the broadcast rights for a particular sporting event. That can be a World Cup, that can be Olympics, that can be a FIFA World Cup. So uh, a telecommunication partner, a TV channel, they will like buy the broadcast right from the federation or the global association of the sport conducting event. So from there, they will buy the broadcast right. As far as employment contracts is concerned, you need to ensure, say, for example, you are a startup and you have a five-member team, right? You need to ensure, you need to do proper, you need to like proper contract agreement with your employer and the employee, that stating that you should not disclose the uh, sensitive and confidential information. If at all you leave from the company, you need to ensure that you are not like misusing our IP. Okay. So these are the use cases of our contract-based intangible assets. As far as technological-based intangible assets is concerned, as I mentioned earlier, patents. Using patents, you can protect your innovative technological aspects of doing things better. Okay. Say for example, you are doing some improvisation in the existing technology, you can go for patent. Okay. As far as computer software is concerned, everyone knows like it is a technology. It is the like clear and concise way of presenting your information in a logical and sequential way, so that your data can be mastered, and your data can be like uh, drive business, sales, marketing, and customer ecosystem. So that is the reason like everyone is developing software. Software, what it does, it minimize human intervention and does the work by itself, right? So this is what software does. So computer software can be protected under copyrights. But as far as India is concerned, you cannot file patent for computer software. But in other countries like US and UK, you can protect your say for example, you are developing some software, you can protect it under both patent rights and copyrights. But as far as India is concerned, you can protect your software only under copyrights, because as per the patent rules, they classify computer software under like non-patentable things. So because that's the reason like you cannot like go for a software patent in India. But they have done some recent amendments in like Indian patent law, that there are certain things that it was like because like since like everyone is developing innovative software, there are some certain ways you can like uh, there are certain techniques where you can tell that your software is doing some like innovative or impression of like existing thing uh, which improvises the like that is the product. So as far as the trade secret is concerned, the prime example, as I mentioned earlier, is like the formula of preparing Coca-Cola, the formula for preparing KFC, like chicken, and like all those things will come under trade secrets, because that trade secret is the value of a brand. Okay, only the competitive advantage or a business value of your product is protected as a trade secret, only then you can sustain in the market. Okay. Top brands are the prime examples, as I mentioned earlier. KFC, Coca-Cola, or the like they are in market like since its existence, like since Coca-Cola was in the market since 1970s, and KFC is there like since 1980. So, and it is like they are franchising into almost all parts of the world. Okay, that's the trade secret is concerned. But so as far as the intangible assets, as I mentioned earlier, as far with respect to IP, the intangible assets are brand and reputation, copyright and design, innovation, trade secrets, software and database, work documents, and publication. So, as far as with respect to IFERP, uh, the standard operating procedure and the technical journals, they are doing some a lot of stuff in collecting the information and presenting the information where user can read, right? Because those things we are putting lot of hard work, lot of time to gather those things, gather data, and publish, so that every user can come and view and get benefit out of them. Benefit in the sense they can learn, they can they can understand, or they can share their knowledge uh, to other people. So work documents plays an important role, right? So you need to ensure your work document is not going to a competitor. Okay, that is one of the important thing you need to ensure when it comes to IP management and publications. As I mentioned earlier, scientific journals, technical journals, IEEE journals, and all the scientific research thesis documents will come under publications. And one of the prime aspect and one of the fundamental aspect, as I mentioned earlier, you need to ensure before applying for a patent, please like do not disclose or share your content in the public domain, because once it is available in the public domain, anyone can claim them and themselves as the owner. The reason for the reason I'm telling to not disclose your content in public domain is the fundamental rule is anything available in public domain cannot be patented. Okay, please remember that. As far as capital is concerned, these are the things like industry knowledge partnership networks, goodwill, industry associations, and award and certificates. So these are the parameters with respect to the managing assets in a company. So these are the important things that every company should look upon, so that their IP is protected, and they are going into the next level in terms of growth. So as far as checklist of IP assets is concerned, patents, as I mentioned earlier, protection of technological advancement, trademarks, protection of brand names, industrial design, protection of size, shape, and appearance of a product, copyright, uh, all the creative stuffs will come under copyright protection, and confidential information, as I mentioned earlier, unique ways of marketing, customer database, workflow system is nothing but standard operating procedure, and protocols, and other POC documents, and all other documents which has a business value of your product. Okay, and how you maintain your customers, suppliers, your vendors, also one of the important aspects of asset management. Okay, so some say for example, you're selling a product, you're selling a smartwatch, right? So you need to ensure that your smartwatch is the you need to create value for a smartwatch. That is, I'm talking about the pricing policy. Like you need to ensure that you are charging less when comparing to a competitor. You need to maintain that thing when it comes to selling a product, and work culture and the contractual, as I mentioned earlier, contractual relationship with a third party. Say for example, if you are deputing, or if you are working with a third party who's expert in that particular field, you need to ensure that you sign proper confidentiality agreement with the third party's individual consultant, so that you that particular company or that particular individual uh, should not misuse your data under any circumstances. Facebook is the prime example of, as you know, like Facebook influenced US elections, right? And US elections, right? So Facebook CEO has been sued and he has been like taken to the federal court, and he just gave a blunt reply that they have like partnered with a third party company where the third party company stole the data of our users, and they uh, that's the reason they have influenced the that's the reason they have influenced the political result, which say the fate of a country, right? So you need
Karthik,
to
sir.
ensure. Yes.
Sorry to interrupt, but if you're sharing your slide, it's not visible yet. So, are you
Okay.
sharing your PowerPoint or slideshow, anything
Yes.
like that?
Yes, I'm sharing my
No, it's
screen.
not visible actually.
Why so? Can you see me now?
No, sir.
Just a minute.
Yeah.
From now or like from just now
No,
or like
from the beginning. I thought you
oh,
don't
oh,
have
oh
it.
my God.
Yeah.
Oh my
The
God.
second slides alone.
Just a minute. But you can able to follow me, right?
Yes, yes, yes. You were audible, but
Oh, okay. I don't know why I have some problem. I'm I'm just clicking on share screen, but it is not showing.
so you can exit the share screen and you can try do it again. It's possible.
Okay, just a minute. Can you see me? Can you see now?
Yes, sir.
Okay, this is what this is what my second presentation is all about.
Oh,
Intellectual property strategy for an individual and company. I just these are the this is what intangible assets, as I mentioned earlier, limited and unlimited intangible assets. Example of intangible assets: trademarks, internet domain names, non-competition agreements, and customer-related intangible assets like customer lists, order backlogs, and customer relationship uh, things. And the artistic, the one person was talking about the artistic things, right? So performance even live performance even literature works, musical works, motion pictures, and television programs will come under artistic related intangible assets. As far as contract based intangible asset is concerned, licensing agreement where
so
this
sorry
is
to
called.
interrupt again, but
Yes.
your slide is hanged at the same point in the first page.
Okay, but is it fine now?
No, sir. It's the same. But your cursor is moving that we can able to see. You can try exit the
Technical
slides.
problem.
Yeah, you can try exit the share screen and you can connect it again.
Okay.
Yeah, now it's fine, sir. Now
These
it
are fine.
is
I would like to know more from the participants. Like they can ask questions because as far as the presentation is concerned, I have I think I have covered the important aspects of IP.
okay.
Let it be like people can ask questions so that let it be a very interactive session.
So the participant side, they may not speak, but they can ask the questions through chat board.
Okay. Oh, they can't speak. You have designed in such a way that you can't speak or
So
okay.
I will try for that. But till that, the participants can raise their question through chat board. So
Okay. Done. So meanwhile, I try to like connect now whether I see whether it is working now.
So, am I audible? Karthikeyan, sir, am I audible? Hello, Karthikeyan, sir. If I'm audible, please let me know, sir. Participants, if I'm audible, please raise your questions through chat board because there is no any other option to make you unmute from my side. So please feel free to ask your questions through chat board.
Hello, can you hear me now?
Karthikeyan sir,
Yeah,
am I
yeah, I can.
audible?
Yeah, am I audible to you?
Yes, sir,
Yes,
clearly.
sorry. I think there is some problem with internet. That's why I'm not able to like hear you.
Yeah, it's okay,
Now I
sir.
think
I
it's fine, right?
understand.
Yeah, now I think it's fine.
Yeah, so there is no other way than to make them ask their questions through chat board, sir. There is no other options to make them unmute. So
Okay, they can't speak.
yes, so the participants have to raise their
Maybe like
questions through
whoever is
chat board.
interested in like raising have
Yeah,
doubts,
they can
you can.
also raise their hand and we
Okay,
can also ask them individually.
okay.
So the participants kindly ask your questions through chat board or raise your hand, please.
One person has raised hand, like his name is Deepak. Okay, then I'll go for my second presentation, right?
Yes, sir. If no one has any question, you can move forward to your second presentation.
Okay. Can you see my screen? Can you see my screen now?
Yes, sir. Your screen is
Yes.
visible.
Is it moving?
No, sir.
I mean,
It's hanged in same place.
I don't know why.
Yes, sir. It's moving right now.
Okay. I think there is some lag, right?
Yes, sir. That
Yes.
might be a technical issue or
Yes.
network issues.
Is it can you able to see intangible assets?
Yes, sir.
So these,
Now, no, the second one is not yet in this.
yeah, we'll wait. Yeah. Okay. Can you see IP strategy?
No, sir.
Screen name?
We are
Yeah,
able to see like into intellectual property rights. The first one, the first slide.
we'll wait for one minute. Let's see like whether it can able to move.
Or you can also try exiting the share screen and you can also connect it again. Can do that also.
Okay. I think Zoom is little. I cannot able to share my screen, Yuvraj. It is showing like the option is itself is disabled. If at all I go for like share my window screen, I'm just clicking on entire screen. It is showing there is a mirror. So if at all I go for window screen, it is you can able to see only first slide, right? The entire screen option is not.
working for me.
So just give me some time. I'll
Okay.
share the PPT from my side. Would that
Okay.
be okay?
Yeah, fine.
Yeah. Deepak, you have raised your hand. If you have any questions, you can put your questions in the chat box.
Yes. I think someone has raised a question. Just a minute. What makes intellectual property different from real property development? Um, Intellectual property is like protection of your knowledge. That is, whatever things you have conceptualized, whatever things you have done your R&D, whatever things you are trying to bring it to your reality through your knowledge will come under intellectual property rights. Okay, when it comes to like property, like real property development is concerned, please be specific. Uh, I want like what you are like exactly trying to ask, because you are talking about like real property development. In real property, are you talking about like construction, or are you talking about intellectual property in general? Okay.
Karthikeyan, sir, am I
Yes.
audible?
Yeah, you are. I can hear you.
Yes, you can proceed with your next slide, I hope so.
Okay. Can you just move to the fourth and fifth page? That is intangible assets.
Sure.
Yeah, the next slide. I think I have briefed intangible assets. These are the example of intangible assets. There are different types of agreements and examples of. This is the slide which we were talking about. That is the segregation of intellectual property, market capital, human capital. How each one has been interconnected and how the decision making should be done. And these are the checklist of IPs. Uh, I have already briefed out on patent, trademarks, and copyrights, and how the different types of IPs can align with your growth. Okay, in terms of taking your product to the market. Okay, whether you are a startup, whether you are an individual, whether you are an entrepreneur, or you are a student trying out your R&D or doing your engineering final year project. So whatever you do, if at all you feel that you are working on something very innovative and you are working on, because the reason when I talk with the students or when I talk with final year graduates, final year students, uh, when they start doing their project, please do a market analysis on what is required and what is the requirement, what are the problems currently the user face, what are the problems faced by my manufacturer, and what are the areas I need to concentrate. Do some basic research on what is the exact requirement, okay, of the area, whether you are coming from engineering background or a mechanical engineer or a civil engineer or an instrumentation engineer or electronic engineer, whatever maybe your field. You can be an automobile engineer. Please ensure that you have a basic understanding of what is happening in your industry and what industry requires, and do whatever areas I'm working on it. Is it required, or what exactly is required, and what are the areas I need to consider. Do some basic market analysis to understand the requirement of your market. Then start doing your R&D. Then start planning your innovation, and then uh, do some analysis and come up with the prototype. Okay. So as I mentioned earlier, as soon as you develop your prototype, please ensure that you go for patent filing. As far as patent filing is concerned, there are two different ways you can protect your invention. One is you can go for provisional specification and you can go for complete specification. Provisional, I'll tell you the difference between both provisional and complete specification. Say for example, you are a student or you are an entrepreneur, you have an idea. You don't know how you are going to execute an idea, and it will take time, at least 6 to 8 months. So in that case, you can go for provisional filing where your idea is protected, and the Indian Patent Office gives 12 months to file your complete specification. So within 2 months, 12 months, you can develop an idea, you can test your idea, and by the end of 12 months you can like file your complete specification where your technological advancement of your invention can be explained in the complete specification. So If you have an idea, you feel that idea as a competitive advantage, that idea as a business value, but don't know how you are going to execute the idea, go for provisional. If at all you have a complete idea, complete demonstration of how we are going to like solve the existing problem, how we are going to like improvise the existing product, you can go for complete specification. So therefore, if you have only idea, don't know how to like execute it, you go for provisional filing. If you have the complete demonstration and workable model of your prototype, you can go for complete specification. So in either way, your concept is protected. uh, can you move to the next slide, Yuvraj? Next slide. So as far as like the checklist of IP is concerned, work culture. We were talking about work culture and contractual relationship with third parties, consultants, where we share our idea, where we share our important data, right? You need to ensure that it is protected through proper agreements. That is, and skills of the your employees. Okay, and as far as company strategies is concerned, the business value, the market value, and IP value will one of the prime asset of your company. So you need to ensure that is protected. Okay, and say success can only cannot be taught as a lesson. Okay, you also need to document your failed research projects so that the future understand about what are the failures we faced and what are the lessons we learned from the failures. Okay, so all these things should be properly documented so that your time is saved, your energy is saved, and you can like plan to the next step accordingly. So pricing is also one of the prime thing. If at all you sell a product which is if you're selling a FMGC product, FMGC goods like mobile phone or any other bags or clothes or accessories, mobile accessories, you need to ensure that you maintain a proper pricing for all your accessories so that your target consumer is reached, right? Can you move to the next slide? So this is the IP strategy. Make accurate decision about your IP portfolio with industry's most comprehensive patent and trademark rules. So you need to have, you need to like, if at all you're going for like protecting your invention, you are an individual or if you are a company, you need to consult a proper experts, intellectual property experts, so that they can guide you to explain you like how you can protect your invention, how you can monetize your invention, what are the rules need to be followed, what are the rules you need to follow if at all you extend your patent to other countries. Okay, if at all you're going to like extend your patent rights to some other countries, you need to protect and you need to file separate applications in those countries. There are different ways to file international patents like conventional application and PCT. That is a separate area we need to like concentrate in our future webinars. So to add more information to different types of patent application filed in different countries, yes, if at all you're filing your patent in India, only India is protected. If at all you want to protect your patent in US, you need to file a separate application in US. So that is the fundamental rule of like protecting your invention. Okay, can you move to the next slide? So domain names. Okay, so as you know, like whatever the entrepreneurs nowadays, especially from India and from Asia, whether you are in a beauty services or whether you are in a food services, you are actively using social media, right? You are like having your own website, you are having a social media page, or you are having your blogs, etc. Like so, you are maintaining a relationship with your consumer, with your client, with your vendor, right? In those scenarios, you need to ensure your domain name is protected so that your business is also protected and you are moving to the next level. Can you move to the next slide? So this is one of the important aspect which I mentioned during the asset management. That is, ensure that any individual or contract you hire will transfer their IP rights to the company in the work they are doing and materials related to it. Say for example, you are a startup and you are a tech startup and you have a team of 10 software developers. Okay, so you are giving them resource, you are giving them knowledge, you are giving them project to come up with a solution. In that case, you are the sole owner of the IP. Of course, you can like make your worker as a inventor of the patent application, because as far as patent application is concerned, it has the details like title of the invention, name of the applicant, that is company name, and name of the inventor is who are the individuals who worked for this invention. So in that field, name of the inventor field, you can mention your workers who did some work for this invention, who worked along with you, and who did those R&D stuff for taking this invention or taking this improvisation to the next level. So name of the patent, number of the patent, name of the applicant, and name of the inventor. So these are the four important details as far as patent application is concerned. If at all you look any patent, you can see these details on the first page of the patent application. Whether you are doing an whatever the country may be, whether you are filing in India or whether filing in US or UK, the first page of patent application concern these details which I listed. That is name of the applicant and name of the inventor. Okay. So may can you go to the next screen? So confidential information, as this is one of the fundamental thing as far as intellectual property management is concerned. So unless and until you file your patent, please don't post your invention. Please don't post your R&D stuff. Please don't post your photocopies of your prototype in the public domain. Once it is published, you cannot go for patent. Okay, because the fundamental rule is anything available in public domain cannot be patented. So kindly ensure it. Make sure that, say for example, you are an entrepreneur, or you are like going to like start, that is you are owner of a startup, or you are a student, you're working on some like R&D projects. Please ensure that if at all you discuss your idea with any company or any other technological experts, please ensure that you sign a mutual non-disclosure agreement where they will like you mention all the classes of not using your information or not using the data you share or not using the technical aspects you share to someone else, so that they get benefit out of it. You are the sole owner of your IP, because you are like you gave your sweat and blood to like design that design your IP. Okay, you are done like you have worked n number of days and you put in heart and soul for developing that IP. Please make ensure that your IP is not taken or stolen at any cost. Okay, can you move to the next slide? IP due diligence. So this is IP due diligence is an audit. Okay. Say for example, over the period of time, say for example, if you have developed some patents, you have filed for trademarks, and you need to run a due diligence to check whether your IP is used or your IP is unused, your brand name is like protected, or your the validity of patent and trademarks has been protected. Do I use my IP? Do I you is there any unused IPs which I am not using? So you need to ensure that you do a proper due diligence, so that whatever investment you made on intellectual property is transformed into business, transformed into the asset of the company, transformed into the value of the company. So this is one of the prime aspect as far as IP due diligence is concerned. Can you move to the next slide? So the reason why IP management is needed, that is, as I mentioned earlier, strong market position and competitive advantage. It will like say, if at all, say for example, let's take the uh, mobile phones, right? You know the number of mobile phone manufacturers in India. It is more than 3 digits. right? Now, mobile phone manufacturers, I'm not talking about brands, mobile phone manufacturers. Okay, that is OEM, ODM concepts I'm talking about. So, so people are like, say for example, if 10 new brands enter, they can also like sell the products. So the market is wide open, that each and every brand is coming up with some innovation in mobile phone so that they will attract the consumers. So strong market position and competitive advantage and high profit return on investment. Say for example, you are managing your R&D effectively, you can whatever stuff they do in R&D, you can like turn and into the prototype. You can turn the prototype into workable model. You can turn that workable model into a sellable model. A sellable model can like consumer can consume that model, and you can get benefit out of it, and where your return on investment will be very large. Apart from like say for example you're an entrepreneur, you don't have proper infrastructure or you don't have proper medium to like market your product, you can partner with manufacturer, you can partner with suppliers, you can partner with the industry so that your product is manufactured and sold. So that is one of the prime important things. Say for example you are developing an innovative product but you don't have infrastructure, you can like license your product to a manufacturer, where as I mentioned earlier, you'll get a royalty for each and every product they sell, and also profit share for the quantity of goods they sell using your IP. Please move to the next slide. So once you have once you have created IP, you have every right to decide the cost of the IP you created, whether you are selling or licensing or reselling or cross licensing, you gain the power. Okay, and you have the ability to like get money. You can use at a collateral in bank loans, or you can like evaluate your financial asset, because it will come under assets. Okay, assets, as you know, like movable or immovable property, and those things will come under intangible assets, that is rights acquired through knowledge. Okay, you can create benefit out of it, that what it can give you power, and it can also give financial stability to like take your brand or take yourself to the next level. Can you move to the next slide? So these are the other thing, like what are the, if at all you properly manage your IP, so you can like take action against infringers, you can like own your assets, it will like add brand value, it will give positive image, it can be used at a medium to raise funds, you can partner with a MNC company, or you can partner with your own competitor to develop some innovative things. Okay, so Honda and Hero are the prime example. Initially, like Hero and Honda are separate entities, right? They collaborated and they manufactured a motorbike. But currently, they got like their contract got cancelled, and the brand agreement got cancelled. Hero and Honda are operating in it as a different brand. But initially, Hero and Honda operated like they combined as a, they went for partnership, and they like so you don't know who you're going to compete, but in the longer run, if you are reached a level that you are competing to your top competitor, you need to ensure that you reach to the next level, maybe like by partnering with him, or you can license your IP to him, so that like because say for example your competitor has a business value in other countries, it will take time for you to like market yourself in other countries. In those scenarios, you can partner with your competitor so that your product gets licensed in other countries, your product, it creates a market for you in other countries. So you need to evaluate all the aspect of IP, how I can monetize, how I can like get benefit out of it, how I can take it to the international market, because that is the crucial thing. As I mentioned earlier, protecting your patent in India is protects your invention only in India. If at all you want to like protect in other countries, you need to file different you need to file individual application in those respective countries so that your IP is protected. Okay, can you move to the next slide? So initially we were talking about like due diligence. This is audit. The audit like systematic review of companies' IP assets and like risk and opportunities. So whatever things I have listed, that is intangible assets, management of intangible assets, IP due diligence, and IP audit. These are the major important parameters to elevate the value of your IP. See, you have filed for a patent, that is work is not completed once you have filed for a patent. You need to ensure that you apply proactive measures, safety measures, so that you streamline your IP protection, so that your IP is protection of your IP is beyond the number of years. So it is like transformed from the value of your IP, the value of your brand, and also as a combination of your brand power. So this is where IP audit plays a major role. This is a systematic review of and company IP. It is more or less like a information audit, like information security management audit. So almost like every companies will do that, like ISMS audit. So the reason is whether everything is in practicing is in good shape, and whether we are following all standard operating procedure, we are following all data management protocol. So you need to ensure that everything is in right place. So only then your IP assets will have value, and it will they elevate the value of the assets. Can you move to the next slide? So as I mentioned earlier, the mergers and acquisition is nothing but like partnering with a competitor or partnering with a growing company where you can take your product to the next level. If at all you have, as the prime example is, as I mentioned earlier, say for example, if you are like taking your product to an international market, and it take time for you to like do a proper marketing stuff, you can partner with a third party company where you can license your IP and like start selling in those countries. Can you move to the next slide? So licensing and collateral, as I mentioned earlier, you can license your IP to a third party for a particular time frame. A collateral can be used as an IPR to like determine the credit worthiness for an investment for or for an like loan. So please move to the next slide. So these are the different ways of enforcement and costs, and knowing the like how you can like enforce IP and how you can manage IP. Okay. So you need to come up with a different there will be some like issues and like on managing IP, and you need to like follow proper uh, like techniques so that everything is, because you cannot go and file 100 patents, right? MNC can file, but when it comes to an entrepreneur, when it comes to an like individual, you need to ensure that you do proper R&D, proper planning, because uh, you are working on only one thing. You're working on only invention. Of course you're going to working on multiple things, but uh, for instance, you can work only on one improvisation, and you can, if say for example you're going for like you need to ensure that, as I mentioned earlier, you need to do a proper market analysis of what is required in the market. Only then you need to do start doing your R&D. Okay, then you can go for patent. But as far as like multinational company is concerned, the objective of filing many patents is like to strengthen the patent portfolio, so that they are the top players in their own area. Okay, can you move to the next slide? So these are some like facts facts and figures as far as like IP is concerned. In US, nearly 40% of the market value of the average company is absent, because so we need to ensure our IP is like, you need to ensure your IP is like inside the scope of your international risks. Okay, these are some statistics. Since like in IBM, you can say like they have like made nearly like 1 billion US dollars from just licensing their core technologies to third parties. So uh, the reason for filing many patents by the top MNCs is that they can make money out of it. They can create a brand awareness. They can create a brand power and make them stay in the top for a very long time. Can you move to the next slide? Uh, so these are some facts they actually want to say, for example, some of the brand valuation of some important brands like Honeywell and Coca-Cola, the brand estimation was due to their intangible assets, especially intellectual property assets. Can you move to the next slide? So these are some other findings and how they helped to increase the GDP of that particular company, and how it created the generated revenue in terms of IP monetization. Can you move to the next slide? uh, as I mentioned earlier, this is the way you should conceptualize your product. That is idea, development, product, and selling. Say for example, you are doing initial planning and project planning. It will come under patents. Okay, your designs, you need to do proper negotiations and proper ideas, and you need to go for patent filing. And after that, once you do the initial planning, project planning, and design, you need to go for prototyping. Then you need to go for a perfect manufacturer who you can feel you can who you can confidently feel that they can manufacture and your product, and finally to the sales. So this is the way where the IP is for example, before going into the market, you need to protect your design. That will come under patent, right? When it goes to manufacture, the patented concept will go for licensing. Okay, and it will move to the sales. So these are the different types of IPs need to be followed by the R&D team and intellectual property unit, so that your idea is protected at the initial stage, and there is no infringement or misuse of your idea by third parties, and it is you have created an value out of it. So this is the effective use of your intellectual property. Can you go to the next slide? So as far as patent application is concerned, say everyone can file a patent. As I mentioned earlier, you need to do a proper ground analysis of who are the prime players, what is the problem currently my industry is facing, and what are the available solutions, and what are the problems concerned with the available solutions, on what are the improvisation required, what are the out of box solutions needed, and what is the current market trend. So all these analysis you need to do. If at all you are not able to do, you need to hire or consult a proper patent analyst or a patent expert, so that you get all the industry analysis, so that you work on a profitable invention in the sense you are putting your time and effort, right? You need to turn into money. It need to turn into your own brand. So for that, you need to create a strong patent portfolio. Can you go to the next slide? So these are the long term and short term objective in terms of managing your IP, what needs to be done, why I need to file patent, what I'm going to sell, and who are my competitors, and how I'm going to face my competitors, how I'm going to or market my product with respect to my competitor product and services. So these are the short term and long term objectives. And I also need to periodically discuss with my team, so that I will encourage them and get best out of what needed. Please move to the next slide. Yeah, I think I covered long term objectives. Next. Can you move to the next slide? Yeah, this actually IP. The protection of IP is not only for it will you can get benefit out of it. Say for example, if someone misuse your brand, you can sue them. Okay. Bits Bilani Indian Broadcast graduates won a patent infringement case against Apple, where they sued for $862 million for damages. Okay. So they used these two guys have developed some technology, and Apple has used that particular concept with like without their consent, and that particular matter was taken to the court, and Apple have paid them like damaged cost for 864 for their patent, because they have used their concept, they marketed it, and they got benefit, and they got financial benefit out of it, right? So they have sued them for like $862 million, and they have paid them. You can also this is the one of the fact you can you can refer Google for to understand more about the infringement case. Can you move to the next slide? So this I have already mentioned, like in terms of like what are the things we need to follow in terms of research findings. Can you move to the next slide? Oh, as I mentioned earlier, and a proper intellectual property paralegal expert can like help you to like manage your invention, protect your invention, legally follow all the protocols of filing your patent with respect to Indian Patent Act, and with respect to like conventional application and Paris Convention Treaty, where if at all you're going to like protect your invention in outside India. So I think I have covered all the important aspects of IP management. So any questions? Welcome.
Karthikeyan, sir, am I audible?
Yeah, yeah, I can hear you. Hope I covered all the. Hope
Yes,
I
sir.
got
We
all
have come to
important aspect
an
of
end
IP
of the
management.
session. Yes, yes.
Yes, thanks for
So,
organizing this event, because intellectual property is the need of hour, and almost you need to. I think everyone uh, who know IP, who doesn't know IP, through this presentation could have like got some fundamental things before going for protecting the before going for an idea, right? So if at all you can, if they have any doubts, you can call, you can drop a mail. You have my contact details with Mr. Yuvraj.
yes, sir, definitely. It was a wonderful session. No, I hope there was much of
Thank you. Sorry, I
knowledge.
had some technical issue, but initially, I actually the presentation, these things, I have like standard presentation for all aspects of intellectual property management. But initially, I thought it was just a interactive session where people will ask questions, I need to answer. But somehow, these are the presentation which I did very a long time back. But hope this presentation I've gathered all the gave all the necessary information for the participant. And as I mentioned earlier, they can ask, they can raise questions anytime. Over
Yes,
to
sir.
you, Raj.
Actually, many of them have raised a question, I hope. So
Okay,
you can also see through question and answer board and also through chat window.
definitely, definitely.
Yes, sir.
Yes. Okay, thank you, Raj.
You're welcome, sir. You're most
Thank
welcome.
you. Thank you. Someone is asking the PPT. Uh, Maybe you can share my email ID to them, Yuvraj, so that they can come up with their questions.
Sure, sir. You could also share your email ID through chat boxes so the
Definitely.
participants can also make a note of
Yes,
it.
yes, yes.
Yeah.
So it was a wonderful session, and hope I can able to share some knowledge about overall my experience with intellectual property management. And hope
Thank you, sir, for the wonderful session. As we come to the end of our faculty development program on intellectual property rights and intellectual property management, I would like to take a moment to express my gratitude to all of you for joining us today. I would like to start by thanking our distinguished expert, Mr. Karthikeyan Sukumaran, for taking the time to share his expertise and insights with us. Your presentation was engaging, informative, and thought provoking, and we all learned a great deal from your experience and knowledge. I would also like to thank all the participants who attended our faculty development program today. I hope this webinar is value to you. Our second day of FDP will take place tomorrow. The same Zoom link can be used to join the faculty development program. Thank you all.